Good morning. Today we are going to discuss again with the law. In the previous lectures we have seen the theories of law, means the views of Austin, the views of Salmon, the views of Kelsen. Okay. What Austin says, law is a command of sovereign backed by sanction. What Salmon says, laws are body of rules recognized and applied by the state for administration of justice. Kelsen says that rules are what? Laws are what? Norms, isn't it? Laws are norms. Heterogeneous kinds of norms are there. Means all the jurists come and tell to us what law is according to their viewpoint. Okay, one will tell that it is imperative, what one will say it is a command, one will say it is a rule. Okay, now first of all we will see what is the purpose of the law. For the purpose also there is no unanimity among the jurists. One view is different, one school is different, the other school is different. There is no unanimity with regard to the purpose and function of the law. According to one school of thought, object of law is to maintain law and order in the country and perform the police function, means perform the function to protect the society. Okay. Now what Thomas Hobbes says, law was brought into the world for nothing else but to limit natural liberty, means the liberty which we have as an animal, isn't it? Upper animal, higher animal. The liberty which we have, that will be limited because of law, because law is going to restrict your freedom. That is to restrict you, to control your liberty. That is the purpose of law according to Thomas Hobbes. Okay. What John Locke says, end of law, that is object of law, is not to abolish or restrain but to preserve and expand freedom. Just opposite view. One is telling law was brought in the world to limit, to restrict your liberty. John Locke is telling no, it was not there to restrain or abolish, it was there to preserve your freedom, it was there to expand your freedom. Therefore each and every person is going to give different objectives or different purpose. Like Ruscio-Pond has mentioned that the purpose of law is not one or two, there are four purposes of the law. And what are those purposes? To maintain law and order, to maintain status quo, to enable individuals to have maximum freedom, and the fourth is the maximum satisfaction of the needs of people. Okay, those are the views of Ruscio-Pond. Salmon, what is the object of law for Salmon? It is justice. It is justice. So that is the main purpose. Justice is to get justice, to give justice, that is the main purpose of the law. While other purposes which are being mentioned by Thomas Hobbes, John Locke or Pond, and the Hindu view is also there. Hindu view is very vast. Regarding the purpose of law, it should aim at the welfare of the people in this world and also from salvation after the death. Expanded meaning is there, means the purpose of law is not only governing your life in the world but after death also, to get salvation is the objective of law. So there is no unanimity relating to the purpose of the law, but we can say that whatever Salmon has mentioned, that justice is the main purpose. Yes, justice is giving justice is the main purpose of law, and other purposes are also there. Okay, there are certain advantages of law. What are the advantages? Law is uniform. Law provides uniformity and certainty to the justice system. It is applicable to all in a similar manner. Okay, this is the first advantage. Second is what? Law is having fixed principles of justice. Therefore, it avoids the danger of arbitrary and biased decision. Means law is giving you an adequate safeguard against error of judgment. Means if the judge gives a wrong judgment, we know the law. The principles of law is fixed. So we can know it. We can say that yes, this judge has not followed this principle or this provision. Therefore, the arbitrary decision of a judge can be challenged, can be checked with the help of the fixed principles. Fixed principles of law protect administration of justice from errors of individual judgment. Judges are not expected to twist the law. they have to follow the law, and if they twist it, we will come to know. Okay, therefore law is more reliable than individual judgment. Human beings are fallible, they are going to make errors. Judges are not exception to that. Therefore judges, while giving their judgment, maybe they will make error, and if they make an error, we will come to know, and we can challenge it in the appellate court. We can do all these things because of law. Okay, these are the advantages of law. Law is having certain disadvantages also. When we say that laws are fixed, they are so fixed that they have become rigid. They don't change. The lawyers and the judges and all, they are little bit conservative minded. They favor for continuance of the existing legal system. They don't want changes. Therefore, little bit conservative nature is there of law. And law is rigid. Law does not change. There is a gap between advancement of the people and the legal system. Man advances, society advances, and the law remains previous only. Therefore, there is a long gap. Therefore, afterwards, cautiously, with proper studies and all, they change it, they amend the law. But there is a gap. Therefore, rigidity of law is one of the disadvantage. Okay, now when we go for a legal system or when we study law, we see that lots of formalities are there. Form is very much important. Emphasis on substance. A lot of time is wasted in raising technical objections of law, and undue and needless complexities of laws are there. You can say that so much complexities are there that because of which the common man cannot understand the law, and therefore law may help the clever and the crooked, and he may take help of the technical rules and regulations, and he may win the case. Okay, therefore that is one of the disadvantage of law. Okay, law is generally complex in nature rather than being simple. This makes it beyond reach of men of ordinary understanding. We have to remove all these defects which are there in the law, so that law can be properly understood by the common man also. These are the advantages and disadvantages of law. Okay, we'll see the kinds of law then. Okay, law is of territorial nature. It applies to its own territory. Whoever is there within the territory, the things, the human beings and all, the institutes, law will apply to them. Law is having a territorial nature. It means law will not be applied outside its territory. However, there is a concept of extraterritorial jurisdiction also. Sometimes if there is some kind of nexus, law applies extrajudicially. Okay. Now we will see the kinds of law. Substantive law and procedural law. Substantive law is a law which tells you the basic things, the rights and the remedies and all. That is substantive law. And while procedural law means a law which tells you how to file a case, where to file a case, that is procedural law. Example, contract is substantive law. Bharatiya Nyaya Sanhita is a substantive law because it is going to explain to you the basic concepts. It will tell you the remedies also. Okay, but what are procedural laws? Civil Procedure Code, Bharatiya Nagarik Suraksha Sanhita, that is previous CRPC, evidence law, those are all procedural laws. Means types of law we can classify as substantive law, procedural law. Some laws are there which are both partly substantive and partly procedural. Like our Consumer Protection Act is having few provisions relating to substantive nature, which tell about consumer, rights of a consumer and all. And thereafter they provide for the commissions, the state commission, the national commission, and the procedure which is there in the court, in the tribunals. So it is partly substantial and partly procedural. Okay, means this is one kind, substantive and procedural. Martial law. Martial law is a law which is applicable to military, army, navy, air force. The separate acts are there, the Army Act, the Air Force Act, the Navy Act, the separate acts are there. Court martials are there, courts are there which deal with, which hear the cases from those particular laws. The cases of this Army, Navy, Air Force, they don't come to our regular courts. So the law of the military, that is called as martial law. Okay, next is civil law. Civil law is a law relating to civil aspects which provide for a remedy. The main remedy is what? Compensation. Tort law is a civil law. Contract is a civil law. The cases will be filed in a civil court. Next is the criminal law. Criminal law will define what is crime and provide for punishment. The cases are filed in the criminal court. Okay, so civil law, criminal law, substantive law, procedural law, constitutional law, that is a basic norm. As per Kelson, it is a grand norm. So constitutional law, that is a law which establishes different organs of your country, which provides for the objectives, aims of your country, and it tells how laws are to be made and what are the functions of all the three organs. That is a basic law, which is constitutional law. Administrative law, it is a law relating to administration, law relating to management, implementation, execution of laws. There are lots of laws which are there, policies which are there, which provide for administration, and these all are called as administrative law. Okay, constitutional law, administrative law, then substantive law, procedural law, martial law, then you can say public law. Public law is a law which relates to all the public. Constitutional law, administrative law are the parts of, or you can say the types of this laws. Public laws. Private laws. Private law means what? The law relating to. The province of private law is the adjustment of relationship between person and person, whereas the public law deals with relationship between the person and the state. Constitutional law, administrative law are the example of public law, while contract, company law, law of tort, trust, law of trust, they relate with private law. These are the main classification. Divine law is there, which is a law made by the supernatural force. Positive law. Positive law is a law which is made by the parliament. That is called as positive law. Human laws. Human laws means the laws which are made by men. One intelligent being for the other intelligent being. That is called as human laws. Mercantile law. Mercantile law means a law relating to mercantile business aspects like law of contracts, negotiable instrument act, and banking and all. They relate with they are mercantile law. International law. International law is a law relating to international relations. All the countries who are sovereign, they will come together. They will come together and they will make some body of rules and regulations which they feel that they have to follow in between their relations. That is called as international law. So many types of laws are there. Few we have seen just now. Okay, bye bye. See you in the next video.